Okay, we're going to get started. Thank you for joining us. My name is Tesha Stanley. I am an associate in the Public Finance and Litigation Departments here at Ballard Spahr. And today we have put together a team from our Municipal Securities Regulation and Enforcement Group to discuss a topic that has been receiving a lot of attention, the SEC's MCDC initiative. The MCDC initiative represents the SEC's latest effort to heighten the standard for secondary municipal market disclosure, and we have divided the topic into three separate pieces. The first piece will be discussed by Bradley Patterson, who is a partner in our Public Finance Department. He will be discussing sort of the substance of the MCDC initiative. And next we have Matt Duke, who is a partner from Avant Strategic Partners, who will discuss how an issuer or an underwriter would go about discovering the types of misrepresentations that are at issue in the MCDC initiative. And finally, we have John Grugan, who is a partner in the Litigation Department. He will discuss the initiative in the context of the SEC's enforcement authority and recent enforcement actions, as well as the potential consequences to an issuer or an underwriter who decides to self-report. So with that, I will turn it over to Brad.
Thank you very much, Tesha. Good afternoon and good morning to everybody. In order to understand the MCDC, it's important to know first, what is the MCDC? I did a quick Google search, and these were the following results when I typed in MCDC. It stands for the Michigan Community Dental Clinics, Missouri Census Data Center, the Minuteman Civil Defense Corps, and it also comes up with the Municipalities Continuing Disclosure Cooperative Initiative. It is the latter MCDC that we will discuss today. In order to better understand the MCDC initiative, it has helped to review past events that led to its existence. As many of you are aware, in 1994, the SEC brought continuing disclosure to the municipal securities market through the adoption of an amendment to Rule 15c212 of the Securities Exchange Act of 1934. That amendment provides that prior to agreeing to underwrite an issue of bonds, the underwriter for the bonds must determine that the issuer has entered into an undertaking, that the issuer will provide annually certain financial information, and that it will also provide notice of the occurrence of certain events. The official statement for the offering also needs to include a description of the undertaking, as well as instances within the previous 5 years when the issuer failed to comply with any of its continuing disclosure undertakings. Notwithstanding a variety of efforts by the SEC to cause issuers to comply with their continuing disclosure undertakings, which efforts included press releases and petitioning Congress for greater regulatory authority, the SEC determined that issuers were not providing timely and accurate information to the secondary market. For lack of better terms, the SEC became frustrated and decided to take additional actions to improve secondary market disclosure. The first of such actions came in the form of a groundbreaking enforcement actions against West Clark Community School Districts in Indiana and the district's underwriter. In order to better understand this particular action, it's important to understand the facts for the case. In that particular case, the school district failed to file any of its financial reports ever, or it failed to file, and it did not file any event notices. The school district also then sold an issue of bonds and failed to state in its official statement that it was not in compliance with its previous undertakings, something that is required by Rule 15c212. Needless to say, the SEC was not amused, and it came down hard both on the underwriter as well as the school district. The second significant action undertaken by the SEC was the release of the MCDC initiative. The MCDC allows issuers, underwriters, and obligated persons to self-report instances of noncompliance with continuing disclosure undertakings which are not disclosed in offering documents. In exchange for this self-reporting, the Enforcement Division will recommend favorable settlement terms to the Securities and Exchange Commission. And yes, I am doing the quote mark thing with my fingers when I say favorable settlement terms. What are these favorable settlement terms? Well, they are as a settlement that, through a cease and desist proceedings that do not require an admission of liability. For issuers, it means there will be no financial penalties. For underwriters, there will be penalties that range from $20,000 to $500,000, depending upon the size of the issue and also the number of issues involved. The cease and desist orders and the financial penalties for underwriters are not the only actions that must be undertaken if an entity enters into a settlement pursuant to the MCDC. Such actions include establishing policies and procedures for compliance with disclosure undertakings, cooperating with future SEC investigations, and providing a compliance certificate to the SEC 1 year from the date that the cease and desist proceeding is instituted. Underwriters also need to take remedial actions that track a lot of the same actions that issuers need to take. If an entity undertakes a review of its past offerings and finds instances of noncompliance that are not disclosed in the official statement, and that omission is deemed material, how does an entity go about participating in the MCDC initiative? The first step is to complete the questionnaire. Notice the form asks for basic information regarding the issue, including various parties that participated in the transaction, such as bond counsel, underwriters counsel, and the financial advisor, as well as contact information for individuals at each of those parties. Probably the most significant portion of the questionnaire is a section wherein the facts relating to any misstatement are set forth. Care should be taken when completing this section because it may serve as the basis for whether the questionnaire is accepted, as well as it may serve as the basis for any further enforcement action. A couple of final thoughts on the MCDC. First, only issuers, obligated persons, and underwriters can take advantage of the MCDC initiative. And it's only the entities themselves that can avail themselves of the initiative. Individuals at those entities cannot take advantage of the MCDC initiative, and the SEC may still maintain actions against the individuals. Also, it's important to note that failure to take advantage of the initiative may result in more severe penalties. The SEC has stated as such. It could range for fines that are levied against the issuers, and it could result in more severe penalties for other parties that fail to file any types of reports. The MCDC also is revealing for what it doesn't do as much as what it does. As discussed, it offers a sort of amnesty program for certain types of entities, but as discussed, it does not provide the same protection for individuals, nor does the MCDC provide assurance that further action will not be taken. And lastly, the MCDC does not set forth any guidance with respect to materiality. The deadline for the voluntary self-reporting program is midnight Eastern Standard Time. I'm assuming this should be Eastern Daylight Time since it's in September. And so if you decide you would like to participate in the MCDC initiative, we recommend that you start your review sooner rather than later. I'd now like to turn the time over to Matt so that he can tell you how to get started.
Thanks, Brad. Earlier, Brad alluded to reports of widespread issuer noncompliance that may have actually prompted the SEC to develop the MCDC initiative. And I'd like to highlight two specific studies as examples. The first is a study released by DBC Data. DBC Data was actually one of the former NERMSers. And in 2011, they released a study titled Recent Trends in Municipal Continuing Disclosure Activities. DBC found that for any of the 5 years studied, and that was between 2005 and 2009, at least a third of expected disclosures were never filed with the NERMSers. Additionally, over half of issuers missed at least one filing over the 5-year period they studied, and close to 20% of issuers did not make a filing at all. And a similar study was conducted by the California Debt and Investment Advisory Commission. The CDAC study sought to determine the percentage of California state and local government issuers who fulfilled their obligation to file the 2010 CAFR to EMA for bonds issued between 2005 and 2009. Despite all the publicity around the rollout of EMA that year, only 72% of issues sampled showed that a filing was made on time, and about 10% failed to file at all. And so, again, these two studies suggest that a significant portion of the market may have disclosure failures relevant to the MCDC initiative. That's, of course, before evaluating for materiality, but we'll get to that later. And it's important for issuers and underwriters to conduct a thorough evaluation of their organization's exposure. And so, Avant has experience performing disclosure audits, and I'm going to use that as a guideline to describe a basic process for evaluating issuers or underwriters' exposure under MCDC. Okay. The first step simply involves compiling a list of offerings that were issued to the public. Note that private placements are generally out of scope within the past 5 years. Next, you want to look at the statements made, if any, with regards to prior disclosure compliance. So even if no affirmative statements with regards to prior compliance were made, if there were prior failures, a statement should have been made that highlighted those failures to file. And so another question to ask is, were any of the statements misleading? And an example of a misleading affirmative statement can be found in the West Clark OS, and I copied in a snippet of the statement they included in the OS, and it says, in the previous 5 years, the school corporation has never failed to comply. Well, as Brad highlighted earlier, that was absolutely false, and it's the reason the SEC enforcement action was brought against the school district. One last note, for infrequent issuers, note that if there weren't any new offerings within the last 5 years, the MCDC initiative really isn't relevant to your situation. But I would use this as this is good time to go ahead and look at your existing policies and procedures, or if you have none, establish formal policies and procedures around ongoing compliance. Because even if you have existing bonds, you still need to have procedures in place. Step 2, so the next step is to confirm that the statements made in the offering documents were indeed accurate. And that involves researching prior undertakings for all issues outstanding during the 5 years leading up to the date of each issue you identified in Step 1. So, for example, if there was a bond issued in September 2009, an issuer would need to review all disclosure filings going back to September 2004. And that means, depending on circumstances, the disclosure audit may need to go back as far as 10 full years. Prior to July 1, 2009, disclosure filings were submitted to the NRMSers, the nationally recognized Municipal Securities Information Repositories. Reviewing filings made with the NRMSers can be a bit tricky. Not all former NRMSers provide access to historical filing reports, and those that do tend to charge a subscription fee to access historical filings. So the cost of doing an audit can be pretty steep. Of course, on or after July 1st, 2009, all filings have to be posted to EMA, and EMA is accessible for free on the MSRB's website. I've gathered from talking to various issuers that some believe, that their use of a dissemination agent mitigates most, if not all, of their risk. However, I think it's worth pointing out that for most dissemination agents do not actually review the content of the filings they post. They simply post what is provided to them by the obligated person. Additionally, it's not all that uncommon for posting errors to occur. And this is often referred to as a foot fault, and establishing materiality related to those errors will be an important step later in the process. Confirming that a filing was made is only part of the equation. The content of the filing should be compared to the specific requirements outlined in each issue's continuing disclosure agreement. There may be different requirements for different types of issues or credit types. For example, the operating data for revenue bonds often includes supplementary information that may not be included in annual financial statements. Contrast that against the requirements for many GO bonds, where that may be as simple as posting the organization's CAFR each year. A good disclosure audit should confirm that all required filings were made, that they were made on time, and that the content was compliant with the CDA for each bond. And another thing to note is that CDAs for the same credit type, they may change over the years, so be careful not to assume that they're always consistent. You can't just document what's required in a 1998 bond and assume that the 2008 bond of the same credit type is exactly the same. Also, I should point out that EMA, it'll accept any document you upload, even if it's a blank PDF. So again, remember that it's not safe to assume that a filing is complete just because you see it posted on EMA or in the NRMSR. I think it's becoming more common for issuers and underwriters to engage a third party to conduct disclosure audits and issue a formal report. I think there's a greater sense of reliance on something like that. If you do this, be sure that the scope of the review includes a comparison of what was filed against what was actually required. Otherwise, there may be hidden exposure that could come back and haunt you. Disclosure or material events, these are inherently difficult to evaluate. I mean, how would you verify that an event filing should have been made if there's no direct knowledge that the event occurred? And I think for any organization that has staff turnover, this is especially true. We recommend paying especially close attention to ratings events because those are material events that are easily verifiable through simple data mining exercises. And I think most know this, but just in case, the SEC has a backdoor channel into EMA's databases through the MSRB's RegWeb. So I think it's likely that they can efficiently pull data from that and compare that against other data sets from other sources such as rating agency feeds. Step 4, so after reviewing all the relevant disclosure filings and summarizing any lapses in compliance, including the foot faults, the next step is to sit down with legal counsel and evaluate whether or not MCDC is truly appropriate. Recall that MCDC is relevant only if an offering document failed to properly address any prior lapses in disclosure compliance that are material. And legal counsel familiar with SEC rules and enforcement actions can help you navigate Materiality. It's a murky area, and they can help you shed more light on how self-reporting may open the issuer up or the underwriter up to other risks. And John's going to talk about that more in just a bit. And then the final step is, after discussing the specific facts and circumstances with counsel, an issuer and underwriter should coordinate with each other, for all deals that were issued in the past 5 years. And since underwriters' financial exposure is capped at $500,000, there's incentive to report as much as possible, even when materiality may be questionable. And so it's recommended that participants not procrastinate because it's likely to take some time to resolve any inconsistencies or differences of opinion. And now that concludes my portion. I'm going to hand it over to John. He'll take it from here and talk a little bit more about SEC enforcement and the potential for unintended consequences.
Thank you very much, Matt. I think it's safe to say that this initiative has had the desired effect. Everyone in the muni market is talking about it. Issuers and underwriters are looking for guidance. Some law firms, including some with some recent SEC alumni, are encouraging cooperation and referring to it as a no-brainer. But this really is an enormous decision. Once the decision to cooperate and self-report is made, a number of other dominoes fall, including scrutiny of other representations in the official statement and also to the secondary markets, and including scrutiny of the actions of individuals. And so what I'd like to do is to encourage a collective deep breath and start by discussing how we got to this point, because ultimately the federal securities laws still apply and they still constrain the SEC. So we'll talk a little bit about the history, then we'll talk about the SEC's newly sharpened enforcement tools, and then quickly some of the cases that have led to this initiative. And then what I'd like to do is to discuss some practical considerations when determining whether or not to self-report. First, many of our issuer and underwriter clients have been taken aback by the vigor of the SEC's enforcement efforts in this area. This really is the outgrowth of years of attempts to regulate the muni market, and where the SEC has not received legislative support for those efforts. Everyone is well aware of the Tower Amendment shown on the screen, and issuers have taken great comfort in that legislation since 1995. Here, however, is what the SEC recently has said about that amendment. In her 2009 speech entitled Federal Regulation of the Municipal Securities Market, Investors Are Not Second-Class Citizens, Commissioner Elise Walter argued that the financial crisis created the perfect opportunity to regulate the municipal bond market that was then valued at $2.8 billion and later valued at $3.7 billion. Walter argued that more than $391 billion of new bonds and notes had been issued in 2008, and $5.5 trillion of long and short-term municipal securities were traded in nearly 11 million transactions in 2008. She discussed the Tower Amendment as prohibiting the Commission or the MSRB from requiring any issuer of municipal securities to make filings with the Commission or the MSRB. And because of what she described, in her words, as consistently slow dissemination of information, in 1989 she recognized the Commission adopted 15C212, which you're all familiar with, as well as the 1994 amendments to the rule to prohibit underwriters from participating in municipal offerings unless it reasonably has determined that an issuer has undertaken through a contract to provide specified annual information and material event notices. In other words, the SEC employed a workaround because the Tower Amendment prohibited the direct regulation of issuers and the direct imposition of reporting requirements on issuers. The SEC decided to indirectly impose those requirements by requiring underwriters to ensure that these disclosures were made. And so the SEC kept pushing. In July of 2012, in its comprehensive report on the muni market, the SEC urged Congress to adopt several legislative changes that would not repeal the Tower Amendment ostensibly, but in actuality would all but repeal it. For example, the Commission sought legislation that would allow it to require the municipal issuers to disseminate disclosures throughout the term of the securities, including minimum disclosure requirements and also the provision of certain enforcement tools. The Commission also sought authority to establish the form and content for municipal issuers' financial statements, and it sought legislative authority to provide a mechanism to enforce compliance with continuing disclosure agreement and other obligations of municipal issuers. It received none of these powers, however, and therefore again has sought a workaround through this initiative. So where does the SEC find its workaround? Through Section 10B and through Rule 10b-5, the SEC has the ability to charge any issuer, as well as the issuer's officials or its employees, with fraud. It can also pursue claims under Section 17, which gives the SEC the option of charging issuers and officials with non-scienter-based misconduct. These two sections are essential to understanding the MCDC initiative because they represent the carrot and to a far lesser extent, they represent the stick and to a far lesser extent the carrot. The offer essentially is either take the Section 17 non-scienter route or face a scienter-focused enforcement action that may lead to charges under Section 10B. There are a number of penalties that attend to a 10B action and a Section 17 action. They're described briefly on the screen. Essentially, especially with respect to fines, some of the considerations that the SEC undertakes is whether there was fraud, deceit, manipulation, or deliberate reckless disregard of a regulatory requirement, what the harm was to other persons, the extent of unjust enrichment, and the need to deter other acts or omissions. And so it's fairly broad and relatively subjective. In addition to flexing its statutory authority, the SEC also aggressively has been revising its approach to enforcement cases. One change, which really stems from judicial concern relating to settlements, is the new policy of demanding admissions in connection with settlements. Previously, settlements where defendants neither admitted nor denied commission findings were standard, but that is no longer the case, and you can see that from Chair White's statement that's on the screen. Admissions under her new policy, under the Commission's new policy, may be demanded where investors have been harmed or the conduct was otherwise egregious, where the conduct posed a significant risk to the market or to investors, where admissions would aid investors deciding whether to deal with a particular party in the future, and where the recitation of unambiguous facts would send an important message to the market about a particular case. And I raise this new approach because under the MCDC initiative, the staff will recommend neither admit nor deny settlements. As I just said, though, the staff will make that recommendation. There is no guarantee that the Commission will accept the recommendation. The other enforcement development has been on finding responsible individuals and charging them with misconduct, and this really reflects a far different approach in enforcement than the SEC previously employed. It used to be that the Enforcement Division would start with the entity and work its way inward, and then determine, after it had determined entity liability, whether or not there were individuals who also bore some liability. But that has been flipped on its head now. And what the SEC's Enforcement Division now does is it looks at the conduct of individuals and works its way outward. You can see the quotation here from Chair White, which really does reflect the SEC's perspective on individual liability. And this policy is critically important because the MCDC initiative provides no protection for individuals, not for an issuer's, for example, finance director, not for an underwriter's employees or for their supervisors. This lack of protection for individuals is absolutely consistent with the SEC's focus on gatekeeper liability. And what's that? That is the identification of individuals, whether board members, lawyers, underwriters, or others, whom the SEC believes should be playing a role in safeguarding the investing public. And so, consistent with that focus on gatekeeper liability and consistent with this push on pursuing individuals who may or may not be liable, this MCDC initiative provides absolutely no protection for individuals. So I quickly want to go through a couple of cases that I think will demonstrate where we are and also some of the limitations on what the SEC is promising through this initiative. The first case that undoubtedly you all are familiar with is the Orange County matter. There, the SEC found that the county, a district, the Board of Governors, and two individuals variously made material misrepresentations and omissions of fact in the OS for 11 offerings, including the investment strategy employed by investment pools, the investment results, manipulation of the pool's yield. Also, there were misrepresentations about Orange County's financial condition and the tax-exempt status of the offering. And so this is the case that really gets the ball rolling in terms of muni enforcement, and it also signals that there will be some attention paid to individuals, and that lesson was learned in particular in the City of San Diego case, in which the SEC alleged that there had been intentional underfunding of the City of San Diego's pension plan for 5 years. There have been retroactive increases in pension benefits that hadn't been disclosed, and also not disclosed was the use of surplus earnings to pay additional benefits to plan beneficiaries. 5 former San Diego officials were charged with fraud based upon those inadequate disclosures, and they all eventually wound up settling with the SEC out of pocket. There was no indemnification that was able to be provided to them and no insurance that covered. So the City of San Diego case made absolutely clear, if Orange County didn't, that personal liability by officials was likely to become more common, And to just reinforce that, here's what Linda Thompson, then the director of the Enforcement Division, said at the time. She said, "Municipal officials responsible for municipal bond disclosure play a key gatekeeper role in protecting investors. It is therefore imperative that they honor the public's trust by ensuring that investors are provided with accurate material information about issuers' fiscal health." More recently, in May of 2013, the SEC released a 21A report announcing the settlement of a cease and desist proceeding against Harrisburg, the city of Harrisburg. This is the first muni enforcement case relating to disclosures to secondary markets. And it's important to understanding the MCDC initiative because it shows the SEC's thinking in a few respects. First, the SEC again reemphasized the necessity of regular continuing disclosures to investors. It said, in this case, among other things, public officials who worked within the city's administration publicly released statements and information that omitted or misstated material information about Harrisburg's financial condition. It said those misstatements and omissions were not the result of an isolated incident, but were recurrent and stretched from one fiscal year into the next. It said that investors may be more likely to rely upon statements from public officials where written undertakings made pursuant to 15C212 have not been fulfilled, and requiring continuing disclosures are not available through the MSRB's EMMA system. So the SEC clearly, unambiguously, again, emphasized the importance of CDA requirement, but maybe more importantly for today's purposes, the SEC addressed its materiality analysis. It said the statements by the Harrisburg public officials were part of and could have altered the total mix of information available to the market. There is a substantial likelihood that a reasonable investor would consider the financial condition of the city important in making an investment decision, and there were no other disclosures made by the city as part of the total mix of information available to enable investors to consider other information. These public official statements were the principal source of significant current information about the issuer of the security and thus could reasonably be expected to influence investors and the secondary market. Because statements are evaluated for anti-fraud purposes in light of the circumstances in which they are made, the lack of other disclosures by the municipal entity may increase the risk that municipal officials' public statements may be misleading or may omit material information. And so that is critically important, because whether or not self-reporting is required, not whether it's tactically advantageous, but whether it's required, hinges on materiality. And as we'll talk about a little bit later, the SEC has acknowledged that materiality may not be established in every case. The next, this slide shows not only more about the emphasis on personal liability, but also what Commissioner Dan Gallagher said in terms of municipalities don't commit frauds, people do. I spoke with someone today who was talking about the commission and whether or not there are some commissioners who may take a dim view of what the SEC's Enforcement Division is trying to do because of their political leanings. Commissioner Gallagher, a Republican, is very, very measured in his approach, I think, in enforcement. But here you can see what his view is, and so I'm not sure that he's going to provide much relief from this initiative. The case most cited as having led to this initiative is the Wes Clark case, and I'll just quickly go over it since Brad has already addressed it. The critical facts there were that Wes Clark had not submitted any of the required annual reports or notices for a 2005 bond offering, and the underwriter didn't detect the false statement that there had been compliance in the course of a 2007 offering. And so here is what the SEC said. This is the first time the SEC has charged a municipal issuer with falsely claiming in a bond offering's official statement that it was fully compliant with the annual disclosure obligations it agreed to in prior offerings, and an underwriter and its principal for not doing the necessary research to attest to the truthfulness of that claim. Wes Clark Community Schools defrauded bond investors by leading them to believe that it provided the annual financial information contractually required in a prior bond offering, when in fact for 5 years they failed to submit the required information. What the SEC didn't specifically address, as it had in Harrisburg, was materiality. I think that they have touted this case as being the outlier, as being sort of the proof that there must be continuing disclosures, and that the absence of any continuing disclosures is almost per se material. But as we'll talk about again later, I don't think it's quite as clear as that. And now finally, the last case I wanted to mention, and the last case that really informs this initiative, is the Wenatchee case, where the SEC assessed a financial penalty. And what's key about this case is the SEC's stated policy with respect to fining municipal issuers. Here's what it said in connection with that case. This is from Andrew Seresny, who's the co-director of the Enforcement Division. He said, financial penalties against municipal issuers are appropriate for sanctioning and deterring misconduct when, as here, they can be paid from operating funds without directly impacting taxpayers. That's from November of 2013. That is consistent with the SEC's longstanding position. And as proof of that, there's a speech that Chris Cox made in 2007 when he said, to an investor whose life savings are at risk, it's small comfort to know that if things go wrong, a punishment could be imposed. It's even less comfort when you consider that if a penalty were imposed, as is the case in the corporate context, obviously distinguishing corporate context from the municipal context, it would be the defrauded victims themselves who would pay the fine. Municipalities have no money of their own. If the SEC were to fine a municipal issuer, the penalty would be paid in tax dollars from the pockets of law-abiding citizens, your pockets. In essence, victims would be robbed twice, and then it wouldn't just be the original victims who would be out of their money, it would be all of us. And so I mention that because one of the so-called carrots that the SEC is offering is the potential for avoiding a fine to issuers. But I think that when you look at the SEC's public statements, the SEC has at a minimum expressed great reluctance to assess a fine against a municipality where the funds to pay the fine would come from the taxpayers. And so it's a question of whether or not the SEC's incentive here is just the sleeves off of its vest, or whether it's actually a meaningful incentive. So what does the MCDC initiative not cover? We've talked a lot about what it does cover. It does not cover other misrepresentations. So, for example, if there are other misstatements regarding financial condition of the issuer, those aren't covered. And as you can see from the recent enforcement actions, both that we discussed today and that have come out over the last 2 years, there has been great attention paid to the representations made concerning financial condition and the ability to fund payments to bondholders. The SEC has dedicated great resources to that particular issue. It has hired accountants, it has hired individuals from Wall Street, and it has a dedicated enforcement staff that looks at these issues. And so you may walk in, having completed your questionnaire, disclosing that there was noncompliance with some CDA requirements, and you may find yourself in the middle of an investigation that is not covered or in any way preempted by this program relating to your financial disclosures and other disclosures in the OS and also to the secondary markets. Secondly, individuals are not covered. So there is no protection that is being afforded to any officials, to any employees, to their supervisors, or anyone else. This program simply applies to issuers and also to underwriters. Significantly, and I think Brad mentioned this at the outset, when you look at that questionnaire form, individuals must be identified. You don't have to identify every single individual who touched the matter like you would in response to a FINRA inquiry. But you do have to identify the contact person for a number of different entities, including bond counsel, including the underwriter, including everyone at the issuer. And so it's really a short step from there to get the list of everyone at each entity who participated in this offering, and it is also not difficult to imagine that subpoenas will go out shortly thereafter. And then lastly, for the purposes of this slide, referrals to other agencies, including FINRA and state regulators, may occur. And so underwriters who decide to participate in this initiative very likely will see that they have been referred to FINRA. What are some of the collateral consequences of reporting? Well, first of all, the self-reports may be viewed as admissions. what's going to happen is that there is going to be some discussion about whether or not the issuer qualifies for the program, and in the event that settlement discussions are not favorable, the statement can't be withdrawn. It has already been certified on the form, and so it is out there. That may, in turn, serve as a basis for bondholder suits, and it may serve as a basis for other regulatory action. Again, as I've mentioned a couple of times now, the participation does invite scrutiny of other disclosures, and you can easily anticipate other enforcement actions against individuals at each entity who has self-reported. One other topic that ought to be considered are conflicts. Who at the issuer decides whether to cooperate? Is it those involved in the issuance of the security, or those who arguably were the cause of the statements that are at issue? If so, they may be and probably are in a conflicted position in view of the reality that they may face individual liability. And so this isn't an inquiry that can simply be passed back on to the individual who shepherded the issuance through. There's going to have to be some consideration given to who it is that's going to lead that investigation at the entity level. And finally, the public nature of these proceedings ought to be evident. Once the settlement is reached, this will be announced. And as a consequence, there are potential reputational implications for issuers and for underwriters that ought to be considered. So now we're at really the final consideration that I want to mention, and that's materiality. The SEC has acknowledged that some failures to have filed reports may be immaterial. And so when is noncompliance immaterial? Well, unfortunately, there isn't a bright line for that. I spoke with someone this morning who said that he wanted to try to encourage the Commission to release some guidance on what is material and what isn't, but I'm afraid that endeavor, however admirable it might be, won't necessarily be fruitful, because I think the SEC is going to be very reluctant to say that a single instance of noncompliance is immaterial, or provide other sorts of guidelines along those lines. I think instead what the SEC is really doing is it's looking for these self-reports so that it can be assisted in its scrutiny of other disclosures. I think it's very unlikely that they're going to provide any bright line for materiality. But still, there are certain guidelines under the federal securities laws of what is material and what isn't. As we saw in the Harrisburg case, it depends on whether or not the total mix of information available to the market has been altered. And so if there's only been one instance of noncompliance and there were no significant events that occurred during that period, well, that may not have been a material misrepresentation. If, on the other hand, and like in West Clark, the issuer has never filed anything, has never complied with the CDA, and other events occurred that would have been significant to the investing public, well, materiality may be established. While it can't be, there is no bright line here, I think it's really important that we understand that materiality can't be assumed. In a lot of these enforcement actions, I think that the SEC will glaze over some of that analysis because it thinks that materiality is manifest. In other words, it may be demonstrated by the individual's own trading. It may be demonstrated in some way that it thinks is readily available to it, but I don't think it's that clear under the securities laws, and it certainly isn't that clear when you go to put it to any kind of economic proof. And so it shouldn't be assumed. Stating it a little differently, there are no per se violations here. The mere fact of having failed to comply with a CDA is not per se a violation of the federal securities laws, and scrutiny into materiality ought to be employed. So with that, I think I'm going to pass it back over to Brad to talk about some next steps.
Thanks, John. Before I finish up with the next steps, we've received a couple of questions that we'd like to address. First of all, thanks to those who sent in the questions, and if you still have any questions that you'd like to send in while we're on this call, please feel free to do so, and we'll try to address them as we can. One of the first questions that we received was whether or not there are any best practices and procedures regarding the MCDC initiative. So far, to my knowledge, and I invite all of my colleagues to jump in and share their views as well, to my knowledge, there has been no professional organization that has come up with a policies and procedures guideline specifically for MCDC. I know there's some policies and procedures for continuing disclosure generally, but there aren't policies and procedures in place right now specifically for MCDC. Another question we had is how far back an individual has to go for purposes of MCDC. Generally, you've got a 5-year window in terms of statute of limitations for fraud actions and the securities law. So essentially what you're doing is you're going back 5 years. But bear in mind that what you have to do as it relates to the MCDC is you're looking for instances of material misstatements in your official statement within the past 5 years. And technically, what it means for purposes of compliance with your continuing disclosure undertakings, you have to disclose instances within the previous 5 years. So technically, you may need to go back 10 years to your continuing disclosure undertakings to see whether or not you were in compliance. So for example, if you issued an official statement in 2009, that 2009 official statement may cover continuing disclosure undertakings from the previous 5 years, and so you'd have to go back to 2004. So that's the other question. If a CDA was filed with a NERMSER and not EMMA, is that a violation? In 2009, the SEC changed where annual reports and event notices needed to be filed. Basically, the NERMSERs were changed from the 5 that were then out there, and it was consolidated into just EMMA. And so EMMA was the place where your reports were supposed to be filed. And so I would think that if you were filing with NERMSERs after 2009, you weren't filing in the right places. And so as a result of that, you probably have a violation, maybe not of your continued disclosure undertakings, depending upon how the agreement was written, but certainly of the rule itself, Rule 15C212. And then we have a question with respect to how MCDC affects conduit issuers. It all depends upon what you said in your continuing disclosure agreements. If you did not agree to provide any information, then you don't have to worry about it. But if you did agree to supply some type of information in a continuing disclosure undertaking, whether it was financial information or whether it was even event notices, and you fail to comply with that, then you will want to consider whether or not you want to take advantage of the MCDC. And then one other question that just popped up. Tesha, have you had a chance to? Okay, we already answered that. Okay, timing question. So just to summarize, a couple of considerations. First of all, whether or not you're going to report, first of all, do an internal audit. Go back and take a look at your previous official statements within the past 5 years to see what you said about your compliance with your continuing disclosure undertakings. And then go back 5 years prior to that to see whether or not you were in compliance with your continuing disclosure undertakings. If you find you have a misrepresentation, we advise you to consult with counsel to determine materiality. As John mentioned, this is an area where we don't have any guidance, and so it'd be best to consult with a lawyer to help you determine what materiality is. If there's a potential misrepresentation, analyze the possible consequences of self-reporting. As John mentioned, there are some collateral consequences in addition to filing your report. There could be some exposure on a personal side, and also there could be other actions that get taken against you. And so you'll want to consider those things as well when you make your determination. And if applicable, you'll want to submit your questionnaire and have your counsel enter into discussions with the SEC in order to follow up. I think that's all we have for today. We appreciate everybody's time, and we all hope you have a good day. Thank you.